Okay, hi everyone. So, this is the continuation series of contract. So, we have been doing contract, and this is the third session of contract where we would be referring to some of the other important aspect which we haven't covered till now. So, the agenda of today's session is just to have a quick recap of what we did in the last class, and then we would be moving ahead with the today's session. So till now we have discussed what is contract. Contract can be in a written format, contract can be in oral format. Then we have also discussed the definition of contract, that an agreement which is enforceable by law becomes a contract. Agreement is a wider term, contract can be called as a subset of agreement. Then we have discussed that in case of contract, the intention of party is to enter into a legal relationship. Unless and until that intention is missing, there cannot be a contract. For example, the promise between a father and a son, where the father is promising to give something if son gets into top NLUs. So there it is not, there's the intention is not to enter into a legal agreement. It is just out of love and affection. So it cannot be called as a contract. But where they have signed it, they have made it very clear that in case you don't give me an iPhone, then there are chances that I'll going for a legal suit. So where they have in the on the paper, let's say they have created or they have shown their interest to enter into a legal relationship, then it cannot be called as a, out of love and affection, and it can fall within the definition of contract. Then we have discussed what is offer and acceptance, because when we talk about agreement means offer plus acceptance plus consideration also. So keeping that in mind, unless and until there's an offer plus acceptance, it cannot be called as a contract. Then we also discuss what is specific offer, what is general offer. Specific offer is something which is made to a one specific person to whom you want to have a contract with. General offer is something which is made to public at large, and whosoever comes and agrees for your or accepts your offer, then there's a contract. Then we have also discussed communication plays a very key role. Unless and until you communicate to a person that yes, I want to sell my house, and there is a communication of acceptance from the other person that yes, I want to purchase your house, there's a contract. Unless and until there is no communication, if the person has thought in his dream that yes, I'll purchase the house, but have not communicated, and this person goes and sells it off to some other person, then the person cannot come and claim कि मैंने तो सोचा था मैं खरीदूंगा. आपने सोचा था आप खरीदोगे, तो आपको कन्वे करना पड़ेगा ना अपना एक्सेप्टेंस. सो कम्युनिकेशन ऑफ ऑफर एंड एक्सेप्टेंस इज वेरी एसेंशियल. Then it has to be very clear. There cannot be vague communication, there cannot be any ambiguity in it. It has to be very clear that I want to sell my house. So I want to sell my house called X house. If you want to purchase my house, you want to purchase my house called X. So all these are very important in case of contract. Then there's another concept called as invitation to offer. Invitation to offer does not fall within the definition of offer. Here you are inviting some other person to make an offer to you, and basing on that offer, it is up to you whether you want to accept it or reject it. Then we also discussed the concept of postal rule, that is non-instantaneous mode of communication. There we also picked CLAT 2021 ka paper, where we solved through passes and questions that how offerer becomes bound. Offerer is the person who makes an offer. How the acceptor becomes the bound, that means the person who is accepting the offer, which is also known as promiser, is called as offerer. Promisee is called as the acceptor under Indian law. And then at what particular time the contract is said to be have been completed, this is something which we discussed. Then in that passage itself, we also discussed the instantaneous mode of communication. There were three questions which was based on instantaneous mode of communication, because the last three line of paragraph was focusing on instantaneous, which is through telephonic mode you can say, or through Zoom call you can say, or where the person is in presence of each other. So the moment one says yes, the other one says here's yes, there's a contract. So this is something which we have done till now. Now there's a question for you guys on the screen. Read this question and tell me which one is the right answer. I hope the question is clear today. This type of questions is are being asked in NLUD paper, is being asked in SLAT also, MHCET also. And plus this type of question, if you master, you can easily master CLAT ka, paper pattern and questions also. So keeping that in mind, please answer this. What would be the right choice? So the principle says if a person accepts an offer made by a person, then contract is formed. Fact says Pravod is keen on selling his car to Ritikesh and tells him that he is keen on selling him his car for rupees 1 lakh. Ritikesh tells him that he'll certainly buy the car for the said amount but requests Prabodh to paint the car white. A few weeks pass by and Prabodh receives an offer from Mickey who is willing to pay rupees 2 lakh for the car. Prabodh sells the car to Mickey. When Ritikesh finds out, he is very upset and sues Prabodh, alleging that he breached the contract he had entered into with him. Decide. A. Prabodh is liable for breach of contract because the contract was accepted in its material particulars. Obviously, no. There was a counter offer which the person has made. The counter offer was ki if you'll paint the car white, then only I'll purchase it. So A is not the right choice. B says is not liable because the contract was not accepted. C says is liable because this is a clear case of promissory estoppel. This is not a case of promissory estoppel. Now, what is promissory estoppel? Promissory estoppel is if you have promised something. Basing on your promise, if somebody has done his or her part, then you are bound to perform your promise. You cannot run away from your promise. D is not liable because he was entitled to revoke his offer. Again, nowhere fact is saying that he was entitled, nowhere principle is saying that he was entitled. So here the right choice is option B, that he is not liable because the contract was offer wasn't accepted. There was a counter offer which was made by him. Ritikesh, basically. There's another question also for you guys. Principle says a contract is complete when an offer is accepted by the other party. Clear? Fact says Amitabh and Rekha are negotiating a contract under which Rekha will supply ball bearings to Amitabh's industrial unit. During the telephonic negotiation, Amitabh says, I'll buy your ball bearings at rupees 2 apiece. Rekha's response is drawn out by an aeroplane flying overhead. Is the contract complete? A. The contract is complete as long as Rekha said yes. B. The contract is not complete since Rekha did not say yes. C. The contract is not complete since Amitav did not hear yes. D. The contract is not complete since Amitav did not make a proper offer. Okay, so this is a very interesting question. B will be ruled out because from the facts, it's not clear that Rekha has said yes or no. So it is just saying, question is saying Rekha's response is drowned out by an aeroplane flying overhead. Is the contract complete? So what Rekha responded is not clear. So keeping that in mind, B will get ruled out, D will get ruled out. Now we have to choose between A and C. A says is complete as long as Rekha said yes. C is saying is not complete since Amitav did not hear the yes. Again, we are not sure that whether she said yes or not. So, considering that, we'll assume that if she has said yes, then contract is complete. So, considering that option C is clearly saying that she has said yes, which is not there in the fact. So, option C also gets ruled out. Here, the right choice is option A, that if she had said yes, then the contract is complete. If she has said no, then the contract is not complete. So, we are assuming that whatever she has said, keeping that in mind, will decide the validity. So keeping that in mind, choice A is the right answer over here and not choice C, which most of you have answered. Then this is something which forms the basics of contract, or you can say the valid essentials, or the essentials of a valid contract are these five. This is something which is defined under section 10 of Indian Contract Act. But since CLAT never asks these sections, please don't go into the sectional details. Just for your understanding purpose, section 10 has been mentioned over here, but they hardly mention the section. Sometimes they do mention, like section 4 communication वाले ने उन्होंने mention कर रखा था, but as per CLAT syllabus and all, they don't expect you to know the section. So keeping that in mind, section 10 says all agreements are contract if they are made by free consent. So free consent is the first ingredient of parties competent to contract. Competency is the second ingredient, with a lawful consideration, third ingredient, with a lawful object, fourth ingredient, and fifth one is are not hereby expressly declared to be void. So if these fives are getting fulfilled in a contract, there's a valid contract. Now, to understand this, what is lawful object, what is competency, what is lawful consideration, what is free consent, what not expressly declared void, to give you an idea, the objective of the contract has to be legal, something which is being recognized by law. If there's a contract for something which is an illegal activity or something which is prohibited by law, then lawful object criteria will not get fulfilled and the contract will not be a valid contract. Then, competency of the party. Section 11 defines who all are competent to enter into a contract. So it says a person who is a major, a person who is of sound mind, and a person who has not been expressly barred by law. So basically, it is saying that a minor cannot enter into a contract, a person of unsound mind cannot enter into a contract, a person like insolvent, bankrupt, or for that matter, जहाँ पे law ने किसी person को बार कर दिया है from entering into the contract, they cannot enter into the contract. Then the third one is lawful consideration. Lawful consideration is something in return of something. That means if you go back to barter system, wheat in return of rice is lawful consideration. Wheat be recognized hai, law mein rice be recognized hai. So anything which is having some values in the eyes of law will fall within the lawful consideration. Then free consent, which is consensus ad idem, meeting of mind. That meeting of mind has been freely done. Nobody has forced the person to enter into a contract. Basically, free consent means the contract is not forced by coercion, undue influence, misrepresentation, fraud. In case if contract is influenced by these four, the contract would be a voidable contract. Or if there is a mistake of fact, then it will be a void contract. And last one is not expressly declared void. That means law has not put up a bar on it. Now we'll read each and every ingredient in detail. So today the first which we are going to talk about is, today what we are going to discuss is lawful consideration. So, what is consideration? Consideration is a promise for a promise or something in return of something. Or the legal term for this is quid pro quo. That means something in return of something. Here, example says A sells to B 500 bags of grain for rupees 1 lakh. Consideration from A to B is 500 bags of grain, and from B to A, it's rupees 1 lakh. So, both the parties are getting something. एक को 500 बैग ग्रेन का मिल रहा है, दूसरे पार्टी को 1 लाख रुपया मिल रहा है. दैट मीन्स समथिंग इन रिटर्न ऑफ समथिंग इज गेटिंग फुलफिल्ड ओवर हियर. The essentials of a valid consideration or a lawful consideration is it should be legal, as I just stated, that it should be recognized by law. That means if somebody says that you give him, let's say, 50,000 and that person will pray for you that you will get into NLS Bangalore. So here, prayer is something which is not your kind of lawful consideration. Thodi hai wo. It has to have some values in the eyes of law. Even without giving 50 lakh, somebody can pray for you. Or prayer said to you would not be getting into NLS Bangalore. So it has to have some values in the eyes of law. For example, here it is written B asks A to give him rupees 50. In return, B would pray to God that A gets a beautiful wife or a son or a good job, etc. Here there is no consideration and hence there is a no contract. Then the very next line says adequacy is immaterial. Not whether consideration is adequate, but whether it has some values in the eyes of law. So, for example, A offers to be a plot of land worth rupees 50 lakh for a consideration of 65 lakh. अगर आपका 50 लाख की प्रॉपर्टी आप उसको 65 लाख में बेच रहे हो, you are allowed to do so because you have a right to increase the price. A offers to be a plot of land worth rupees 50 lakh for 50 lakh. If you want to sell it at the same rate, you are allowed to do so. A offers to be a plot of land worth rupees 50 lakh for 10 lakh. Again, it is allowed because 10 lakh is also having values in the eyes of law. Or for that matter, even if he wants to sell it for 10 rupees, that is also justifies because 10 rupees is a legal tender. So you may feel like this person is, insane. He is selling a 50 lakh ka property for rupees 10, but it is a lawful consideration because rupees 10 is also having values in the eyes of law. So this is something which is being taken into consideration. And then in the last question which we were talking about, we discussed about unilateral promise and promissory estoppel also, that if you have promised something, basing on your promise, if somebody has done something, in that case it's a valid consideration. So this is an exception to the general rule of consideration. When one person does something, acts at the instance of another, then it becomes a valid consideration. बहुत simple सा example है. If you have ordered something on cash on delivery, so, if the product gets delivered to you, you are bound to pay. Similarly, if you are making the payment pehle, like if you are ordering something from Amazon or Myntra or whichever e-commerce site is there, you have made the payment. So, in that case, they are bound to deliver the product to you because basing on your promise that I am making the payment, they are supposed to fulfill their part of job. For example, here also it is saying said that A and B were watching a movie in A's house. A asked B to go get a pizza and that he would pay B for pizza when he gets it. B accordingly goes and gets a pizza. Letter A refuses to pay. Is there a valid consideration? Yes, because the other person promised you that you please pay for it, then I'll pay. And accordingly, you went ahead and you made the payment. So now the person cannot run away and he has to pay for pizza. Similarly, the second example says A wanted to get the community hall repaired. He approached B in order to arrange fund. B promised that he would contribute rupees 50,000 to the project. A got the hall repaired. When he asked B to give him the promised rupees 50,000, B refuses, saying that there's no consideration. In this case also there's a consideration because he promised, then only the person went ahead and constructed the hall. So keeping that in mind, the person is bound to pay. There is another concept under consideration. The concept is privity to contract, जिसका जनरल मीनिंग होता है कि अ पार्टी, आई मीन द कॉन्ट्रैक्ट, लेट्स से देयर इज ए बी एंड सी. Contract is between A and B. So C has no role in this particular case. So he cannot claim anything out of the contract. He is a stranger to contract. He does not have a right in contract. But, and this is something which is very much applicable under English law, that a third person who is not party to contract does not have any say in the contract. But if you take into consideration Indian scenario, or for that matter, exceptions to privity to contract, court has taken this view that even if a person who is not party to contract somehow is getting benefit out of the contract, then he does have a right to claim it. He does have a right to go for it and claim his right. There's a very famous case law from this perspective. Again, you need not to go into the details of the case, but just for reference purpose, because I'm explaining it, I'm telling you the name. So the case is Chinaya versus Ramaiya. So in this case, what had happened? The mother, she gave made a gift deed in the name of her daughter, but she asked her daughter that you would be paying certain amount to your uncle in return of this gift deed. Daughter agreed because she was getting property from her mother, so she agreed that okay, I'll be paying this much of amount to uncle. But later on, she refused to pay the money. Now, uncle filed a suit. Uncle moved before the court of law that his right was involved. He was supposed to get certain money every month. His niece has refused to give him the money. So, in that case, he moved before the court of law. Here, court said that this falls within an exception to privity to contract, And because here there was an interest of uncle involved, उनको हर month पैसे मिलने थे. So his interest, his right is involved in this particular case. So court held that even though he is not party to the contract was between mother and daughter, but his benefit is concerned over here. He is entitled to get the money. He is entitled to get, the money from his niece, and accordingly court held the or gave the judgment in the favor of uncle. So basically the idea is, even a third party or stranger to contract can claim benefit out of contract if it is for his benefit, it is if it is for his necessity, or his interest is involved in this particular case. So this is all about lawful consideration. Then the next one is consent. A brief idea about consent for now. We would be discussing mistake, coercion, undue influence, misrepresentation, and mistake in the next class. But to give you a brief idea, as we discussed, consensus ad idem means both parties agree upon the same thing in same sense. That means if I am saying I want to sell my house for 50 lakh, somebody has to agree for the same thing, that 50 lakh mein kharidna. The example which we discussed just now, Pravod and Ritikesh wala, there was no consensus ad idem. There was no meeting of mind when Ritikesh said that you have to paint the car white. So, a contract can be bad for if the consent is not freely given, or if the consent is under these five categories: mistake, coercion, undue influence, misrepresentation, and fraud. Here, when we take into consideration mistake, that means mistake is with respect to, let's say, identity of the mistake is with respect to a minor or a major. You believe that a person is a major, but actually he is a minor. So in that case, it's a void ab initio. That means since the beginning, contract is not a valid contract and you cannot enforce. So there is no consent. A minor is not entitled to give consent, as we just discussed in the competency to party. Then invalid consent or no free consent is one is mistake. So always remember that in case of coercion, misrepresentation, undue influence, and fraud, the consent or the contract becomes voidable. Only in case of mistake, the contract becomes a void contract. Coercion, coercion is basically where somebody is threatening you to enter into a contract, and if you don't do so, they will do something which is prohibited under criminal law. For example, putting a gun on somebody's head and saying that you sign this paper, or you give your property or deliver your property in my name. So there's a coercion. Out of fear, the person will enter into a contract. So he has a right to declare the contract voidable. The second one is undue influence, where the other party is in a position to influence your mind. Anybody can, that can be anyone, that can be the person who is having some sort of influence on you. For example, again a very hypothetical example, a lawyer and a client, a doctor and a patient, a teacher and a student. Whatever, let's say I'm teaching right now, you guys are believing it, right? Because you have faith in me. So here, if I start, let's say I start using my position to undue influence you, so in that case the contract will become voidable. The third one is misrepresentation. Misrepresentation is where you believe something to be true, and that is your genuine belief. You don't have an intention to deceive the other party. आपको लगता है ये सही है, इसलिए आप ऐसा बोल रहे हो, and because of which the other person believes it to be a true statement, and they enter into a contract. Later on they realize that, oh, this is something which is not true. So there they have an option of declaring the contract as voidable. And the last one is fraud. Fraud is, there's a difference between misrepresentation and fraud. In misrepresentation, your intention is not bad. In case of fraud, your intention is bad. You want to deceive the other party, and thereby you don't say anything. Or you know that this product is defective, but सामने वाला आपसे पूछ रहा है कि is this product defective? You said no, 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 this product is very perfect. So there the contract has been entered through fraud. So there also they have an option of declaring it to be a voidable contract. And the last one is mistake. Again, there's two terms: mistake as to law, mistake as to fact. Mistake as to law cannot be a defense no matter what. because then everybody will get up and say मुझे law नहीं पता था. So keeping that in mind, this is applicable throughout, whether it's civil law, criminal law, whichever section is there. No person can take the defense of not knowing the law. So mistake of law is not a defense. Mistake of fact again can be of two type, with respect to identity, with respect to subject matter. And in both these cases, the contract becomes a void contract. So always remember, चार केस में voidable होता है, एक केस में मिस्टेक के भी दो होंगे, सब्जेक्ट मैटर और आइडेंटिटी, दे the contract becomes a void contract. So this is all about today's session, guys. If you have any question, you may ask. And if there is no other question, then we'll see you guys in the next class. We'll continue ahead with contract ka series only abhi. For next 2 3 sessions, we'll be doing contract and then we'll move ahead with some other subjects. Okay, ठीक है then. See you guys in the next class. Thank you.